Good day, everyone. My name is Jade Downey, and I'm going to discuss the chapter 3, which is the law, obligations, and contract. So, for the learning objectives, identify the different kinds of obligations and contracts, enumerate the ways of extinguishing an obligation, and lastly, is to enumerate possible applications of contracts in the tourism, travel, and hospitality industry. So let's talk about the law. A person desiring to engage in the business in the tourism, travel, and hospitality industry will meet certain obligations. Agreements arising from contracts will have to be made, and potential breach from these agreements will be encountered. Therefore, there is a need to study the fundamentals principles involving law on obligations and contracts. Anyone wanting to start a business in the tourism, travel, and hospitality industry must fulfill certain legal obligations. This includes entering into contracts, such as agreements with suppliers, employees, or clients, which outlines the rights and responsibilities of each party. However, there is always a possibility of breaches, such as failure to deliver services as promised or disputes over terms. Understanding the fundamental principles of obligations and contracts is essential to navigate these legal challenges, ensure compliance, and protect business interests. Proper knowledge of the law helps prevent conflicts, resolve issues effectively, and maintain smooth business operations. So, the discussion of the law. In Article 1156, the definition of obligation. An obligation is a legal duty that requires a person to give something, perform an action, or refrain from doing something. Since it is a judicial necessity, failure to comply can lead to legal consequences, such as being sued or required to pay damages. Obligation as a legal duty. Obligations can arise from laws, contracts, quasi-contracts, acts of negligence, or crimes. Then when a person violates an obligation, then the injured party has the right to take legal action to enforce compliance or seek compensation. Contracts and obligations. Contracts are agreements between two or more parties that establish obligations. For example, in a hotel business, a contract with a supplier for food deliveries creates an obligation for the supplier to provide goods and for the hotel to pay for them. There are 4 elements of obligations. First, active subject. This is the person who has the right to demand fulfillment of the obligation. So, for example, in a hotel contract, the hotel is the active subject when requiring a vendor to deliver supplies. Number 2, passive subject. The individual or entity responsible for performing the obligation. In the same example, the vendor supplying goods is the passive subject because they must fulfill their contractual duty. Number 3, object or prestation. The specific act that must be performed, whether giving something or refraining from an act. Number 4, judicial time. The legal bond that connects the active and passive subjects, creating enforceable rights and duties. This bond is usually established by a contract, law, or other legal means. Types of obligations. The following are the obligations of the passive subject in. Then first is obligations to give a determinate thing. A determinate thing refers to a specific identifiable object. So it has the following duties such as to deliver the thing. The debtor must hand over the exact item agreed upon in the contract. For example, if a hotel agrees to provide a presidential suite to a guest, they must deliver that exact suite and not just any other room. To take care of the thing with the proper diligence of a good father of a family, the debtor must maintain the item with reasonable care, ensuring it remains in good condition until delivered. This means, for example, that a hotel storing a guest luggage must prevent damage or loss. To deliver all its accessories and accessions, the debtor must provide everything that naturally or legally belongs to the item. For example, if a hotel rents out a function hall, it should include necessary accessories like tables, chairs, and sound systems if those were agreed upon. To pay damages in case of breach of obligation, if the debtor fails to deliver or damages the items, they must compensate the creditor. For instance, if a hotel loses a guest's luggage, it may have to reimburse the guest for its value. So next is number 2, obligation to do. These obligations require the debtor to perform a specific action or service. If the debtor fails to do what he or she is obliged to do, it will be done at his expense. If a service provider fails to fulfill an obligation, the creditor can have someone else to do it, and the debtor must cover the cost. For example, if a contracted event organizer fails to set up a wedding venue, the hotel can hire another organizer and charge the original one for the expense. If the work is done in contravention of the obligation, it will be redone at the debtor's expense. If the debtor does the work incorrectly or not according to the agreed terms, they must redo it at their own cost. For instance, if a decorator sets up a venue in a style different from what was agreed upon, they must correct it without additional charges. If the work is poorly done, it will be redone at the debtor's expense. If the debtor delivers the substandard work, they must fix it at their own cost. For example, if a catering service provides low-quality food at a corporate event, they may have to redo the catering or offer compensation. These obligations ensure fairness and accountability in contracts, particularly in industries like tourism and hospitality, where service quality and reliability are crucial. Sources of liability and obligations. The sources of liability of a party in an obligation are as follows. So first is the fraud. The fraud is incidental fraud, which is a fraud incident to the performance of an obligation. In fraud, there is an intent to evade the normal fulfillment of the obligation and to cause damage. Then the second is negligence. The negligence referred here in the case of contracts is a culpa contractual, the lack of diligence or carelessness. Negligence consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons or the time and of the place. Application of the law. The case of Dr. Philippa Pablo versus Alitalia Airlines. Dr. Philippa Pablo, an associate professor and research grant, booked a flight with Alitalia Airlines to attend a United Nations meeting in Italy. Upon arrival in Milan, she was informed that her luggage, which contained crucial research materials, was delayed. Despite her efforts to locate it, she failed to retrieve her belongings on time, preventing her from attending the conference. The luggage was only delivered to her 1 month or 11 months later, long after it was needed. Legal opinion. Yes, Prof. Pablo should be entitled to nominal damages. Apart from this, there can be no doubt that Dr. Pablo underwent profound distress and anxiety, which gradually turned to panic and finally despair from the time she learned that her suitcase were missing up to the time when, having gone to Rome, she finally realized that she would no longer be able to take part in the conference. As she herself put it, she was really shocked and distraught and confused. Certainly, the compensation for the injury suffered by Dr. Pablo cannot, under these circumstances, be restricted to that prescribed by the Warsaw Convention for delay in the transport of baggage. A debtor is considered in delay when they fail to fulfill their obligation after a demand has been made by the creditor. However, demand is not necessary in the following cases, such as when the law explicitly states that demand is unnecessary, when the contract specifies the demand is not required, when the time is of this essence, and when the demand would be useless. The basis of legal obligations. Obligations arise from various sources under Article 1157 of the Civil Code. So first is the law. Some obligations are imposed by the law, such as paying taxes. Next is contracts, agreements that create enforceable duties between parties. Then next is quasi-contracts, legal obligations that arise even without a formal contract, such as when a person benefits from another service without prior agreement but is still expected to compensate for it. Next is acts or omissions punishable by law. Criminal actions create liability, such as paying restitutions for theft. Then quasi-delicts. A person is responsible for damages caused by negligence even if there is no contractual relationships, like an hotel being liable guest injury due to unsafe premises. Discussion of the law. Obligations arise primarily from the two sources of law and contracts. While quasi-contracts, crimes, and quasi-delicts may seem like separate sources, they are actually obligations imposed by law. As established in Leon Ben v. O'Brien, a contract is defined as a meeting of the minds where one party binds themselves to give something or render a service to another. Quasi-contracts, on the other hand, arise from lawful, voluntary, and unilateral acts that prevent unjust enrichment and at another's expense. The two common forms of solution indemnity, the negotiatorium gesto, the civil obligations arising from criminal offenses are governed by the revised penal code and the civil code on damages in moral, exemplary, and nominal damages. Quasi-delicts, and also known as culpa contractual, refer to negligent acts causing damage without a pre-existing contractual relations. Classifications of obligations. The first is the primary classifications of obligations under the Civil Code, such as pure and conditional obligations from Articles 1179 to 1192. Next is obligations with a period, Articles 1193 to 1198. Then alternatives to and facultative obligations. Then joint and solidarity obligations from Articles 1207 to 2022. Then divisible and divisible obligations from Articles 1223 and 1225, and obligations with a penal cause from Articles 1226 to 1230. Then the secondary classifications of obligations under the Civil Code, the unilateral and bilateral obligations, then from Articles 1169 to 1191, and the real and personal obligations from Articles 1163 to 1168. The civil and natural obligations from Articles 1423, and then the legal, conventional, and penal obligations from Articles 1157 to 1159 and 1161. Modes of extinguishing obligations. Obligations are extinguished through various means, including payment or performance, loss of the object due, condonation or remission, confusion or merger, compensation, and novation. Additional causes include annulment, rescission, then fulfillment of a resolutory condition, and prescription. Discussion of the law. The fortuitous events. A fortuitous event, also known as force majeure, exempts an obligor from liability if the event is unforeseeable and unavoidable rather. So the examples include cultural disasters, war and robbery, and with violence. However, negligence can still be if proper precaution were not taken. What is a contract? A contract is an agreement between two or more persons where one binds themselves to give something or provide a service. This agreement is based on the mutual consent of the parties involved and is legally enforceable. Essential elements of a contract. A valid contract must include three essential elements. First is consent. The agreement must be clear and both parties must fully understand and accept the terms. Second is object. The subject of the contract must be specific and lawful. Then lastly is the cause. There must be a valid reason or purpose for the agreement. Characteristics of contract. Contracts possess the following characteristics. First is mutuality. Both parties must agree to the terms. Then autonomy. Parties can freely define their terms as long as they follow the law. Then relativity. Contracts only bind those who agree to them. Then consensuality. Most contracts are valid through agreement alone. Then lastly is obligatory force. Once agreed, a contract must be followed. Classifications of contract. Number 1, according to their relation to other contracts. First is preparatory, or those which have for their object the establishment of a condition in law which is necessary as a preliminary step towards the celebration of another subsequent contract. Then B, principal, or those which can subsist independently from other contracts and whose purpose can be fulfilled by themselves. Then letter C, accessory, or those which can exist only as a consequence of or in relation with another prior contract. Then number 2, according to their perfections. Letter A, it's consensual, or those which are perfected by the mere agreement of the parties. Then B, real, or those which require not only the consent of the parties for their perfection, but also the delivery of the object by one party to another. Number 3, according to their form. First is common or informal, those which require no particular form, for example, loan. Then B, special or formal, or those which require some particular form. So for examples, donations, chattel, mortgage. Then number 4, according to their purpose. A, transfer of ownership. B, conveyance of use. C, rendition of services. Number 5, according to their subject matter. A, things, for example, sale, deposit, or pledge. Then B, services, for example, agency, lease of services, labor. Then number 6, according to nature of the vehicle, according to the nature of the vehicle in which they produce. A, unilateral, or those which give rise to an obligation for only one of the parties. Then B, bilateral, or those which give rise to reciprocal obligations for both parties. For number 7, according to their cause. A, onerous, or those in which each of the parties aspires to preserve for himself a benefit. B, gratuitous, or those in which one of the parties proposes to give the other a benefit without any equivalent or compensation. Then 8, according to the risk involved. Letter A, commutative or aleatory. Then number 9, according to their names or norms regulating them to nominate or innominate. So that's all for my report of the Chapter 3, the Law on Obligations and Contract. Once again, I'm Jade Claire G. Downey, and I hope that you learned something in this report.